morning, ladies and gentlemen. Usual litany, would everybody ensure that all electronic devices are turned off or switched to silent mode? Tea and coffee are not allowed in the committee room. We're continuing line by line consideration of the Terminally Ill Adults End of Life Bill. I remind members that interventions should be short and raise points of clarification or questions. There should not be speeches in and of themselves. At that point, I'll interrupt myself. Simply to say, members may have noticed there have been occasions when I, at least, have allowed slightly longer interventions. Two reasons for that. One is because there is a natural flow in debate that sometimes warrants a slightly longer intervention rather than a later speech, which then becomes irrelevant. But please don't construe that as being an encouragement to make long interventions. A ton of bricks may come down upon you. Members who do wish to give speeches should bob, please, and continue to do so throughout the debate in which they take part, until they're called. Now, I have a list of people who bobbed at the end of the last session, but it would be helpful, I think, to the clerk and myself if we were to refresh that. So, whoopsie, wait, not yet. When I start, dear oh dear. Eagerness is impressive. So when I start to call people, perhaps those who wish to participate in this debate could bob again. And please do remember that when members say you, they're referring to me or the chair, and that should not be used to refer to each other. Debate should be through the chair. So we now continue the debate on clause 12 stand part, with which it is convenient to debate. Amendments 371, 61, 372, 62, 373, 377, 63, 378, 64, 381, 65, 388, 66, 390, 391. New clause 14, new clause 15, new clause 17. Amendment A to new clause 17, new clause 21. Amendment D to new clause 21. Amendment C to new clause 21, Amendment E to new clause 21, Amendment A to new clause 21, Amendment B to new clause 21, new clause 2, new clause 3, Amendments 67, 68, 69, 70, new schedule 1, new schedule 2, Amendment C to new schedule 2, Amendment A to new schedule 2, and Amendment B to new schedule 2. I trust that's absolutely clear to everybody. Now, at the end of the last session, I understand that Ms. Paul very graciously and courteously sat down in order to enable the adjournment to be moved, because as you all have worked out by now, you cannot move an adjournment while somebody is speaking. But she hadn't finished what she had to say. So on that basis, Rebecca Paul has the floor, please.
Thank you, Chair. I intend to speak on new clause 17 and new clause 21 and my associated 4 amendments to these clauses. There's a lot to say, so please do bear with me, but I will do my best not to repeat. So I rise to ask the question, how exactly will the panel operate and function? I appreciate some of the explanation already provided by the sponsor, and I look forward to hearing from the Minister on this point. But I have concerns around exactly what the panel will do and how they will do it. I would do my best to not repeat what others have already said, but I would reiterate concerns around whether this is indeed a better safeguard to the High Court one originally envisaged, given it has no formal judicial role. And on a practical level, I would question whether it's even feasible to find sufficient numbers of psychiatrists and social workers that are able and willing to perform this very burdensome role. As we all know, social workers do an incredibly important job, but those people with their skill set are in extremely high demand. I note the sponsor has made it clear in her opening that she did not remove the High Court judge safeguard because of capacity concerns coming out of the oral evidence we heard in January, but because she believes this is a truly better and safer model. I am also concerned that something that was originally meant to bring judicial oversight to the process has been replaced with something that is not judicial. However, I want to put on the record my welcoming of more involvement from psychiatrists and social workers, as I think they have a key role to play in this process. But I do have concerns around whether the panel is the right place for that. I would suggest their expertise to be more valuable earlier on in the process, when the coordinating doctor and the independent doctor are performing their assessment, rather than at the stage with a legal oversight component. Their involvement in a truly multidisciplinary approach during the clinical stage of this assessment process would have been a truly gold standard safeguard. However, unfortunately, that approach was not put on the face of the bill. Coming back to the basics of how the panel will operate, this is an issue of great significance, and if we don't thrash out the detail of this now, then I ask, when will we? We must have this conversation. I have looked at the new amendments for this information, and according to new Schedule 2, the Commissioner may give guidance about the practice and procedure of panels. And that is all there is. I can't see any further information. And disappointingly, it's not even a must for the Commissioner giving guidance, it's a may. So the operation of panels may well change depending on who is in the Commissioner role. Given this is a very new approach for a very new process, I would urge the bill sponsor and government to ensure it is adequately fleshed out to avoid ambiguity. When I imagine the panel, I am not sure what I am supposed to be imagining. Is it an administrative process, 3 people checking the papers, or is it more like a court calling in amounts of evidence? The Honourable Member for Banbury yesterday very eloquently set out the practical realities of these new clauses in terms of witnesses. According to the new clause 21, the panel must hear from at least one of the doctors, but they don't need to question him or her. So what is it exactly they are required to hear? What does hear mean, and does it cover anything specific? All of the items covered by subsection 2, or just some? So new clause 21 doesn't specify. And it's the same for the patient. They just need to hear from him or her. They don't need to question them. But as I'll come to shortly, in exceptional cases, even the patient won't need to be heard from. Again, I would be grateful to the Minister for clarity on what hear means and what she would expect to be covered. What we do know is that the panel must be satisfied of the relevant matters, yet how they are to be satisfied, and even what that means, is not clear. And the only person that must be heard from is either the coordinating doctor or the independent doctor. Just one person. Now that may well be fine, or it may not, but I put it on the record here as I think it's important that we are all clear-eyed on that. If we compare an employment tribunal, someone litigating an employment claim would know well in advance the rules the tribunal would apply, what tests the tribunal would apply to the facts, the legal representation they can have, and how they can appeal and on what basis. This kind of clarity is essential. I can't find that clarity in this new clause. I also don't know whether this panel is inquisitorial or adversarial.
Would you give away that mic?
I will, of course.
I'm very happy to clarify, Chair, that it is not adversarial, it is inquisitorial and investigative.
I thank the Honourable Member for that confirmation. So I will now skip on now that I have that clarity. Thank you very much. One aspect of the panel that gives me cause for concern is that it would not hear from the patient themselves where there are exceptional circumstances. What are exceptional circumstances? The bill doesn't say, it doesn't provide any guidance. Many people with a terminal diagnosis and seeking assisted dying could consider their circumstances exceptional. Many undoubtedly will be too unwell to attend. This means such panels could be making these decisions based on testimony from only one doctor. I am not for 1 second suggesting that people on their deathbeds should have to attend a panel. That is the point of exceptional circumstances, I believe. But I would urge the sponsor and ministers to ensure the much needed clarity around what this means is set out to reduce ambiguity in this area.
Should you give way?
I will, of course.
I'm grateful, and I think it was helpful to hear the sponsor suggest that the system will be inquisitorial, which is not sufficiently apparent in the bill, as the Honourable Lady says. Does she agree with me that that therefore requires this new panel to have proper inquisitorial powers and authority? And at the moment, there is a lack of genuine power to investigate the circumstances, as the Honourable Lady is saying. If it's not going to be adversarial, but inquisitorial, they should have proper powers of making the investigation.
Rebecca Paul.
I thank my honourable friend for that intervention, and he makes a very good point. I completely agree with him on that front. And again, it goes back to being really clear on the face of the bill about what this panel does and the powers it has in order to avoid ambiguity. It's important that we set that out now during this process, rather than finding ourselves in 2 years, if the bill is approved, it all starting to happen and the questions all start at that point. Let's try and answer them now and be really clear about it. Where a panel does not hear directly from a patient, they may be forced to rely on second-hand accounts. In law, second-hand evidence is known as hearsay, and across our criminal and civil legal systems, it is always handled with a lot of provisions and warnings, because second-hand evidence can be inaccurate or of lower quality than hearing directly from a source. But the panel is open to depending on such evidence, and again, we just must be clear-eyed about the risks that come with that. So in summary, I don't believe new clause 21 gives sufficient clarity of information as to how the panel will perform its role and what evidential standard it will apply. We don't know if it's an administrative task or a judicial one. We do now know that it is inquisitorial, so I thank the bill sponsor for that. And we don't know how much it will rely on hearsay evidence in practice. And I say again, because this is really important, it only requires one of the doctors to hear from, and it doesn't need to question them. So, under the bill, would it be legally acceptable for the doctor to turn up, say, no concerns, and that's the end of that? For those on the committee that think that won't happen, if the bill allows it, I'm here to tell you that somewhere, with some panel, it absolutely will, particularly as our society gets desensitised and more comfortable with the concept of assisted dying. So again, I would urge this committee to be precise with the legislation it's passing for the sake of the statute book. And more importantly, for the sake of all the people who may find themselves being assessed by such a panel. I will, of course...
I thank you for giving way. She sketches out a very short exchange there, and I just wondered elsewhere in these sort of matters, whether it's in High Court, employment tribunals, etc., whether she thinks we should be specifying in primary legislation exactly the nature of interactions, because my understanding, we do not. We trust, again, professional people regulated to have appropriate interactions, and it's not for Parliament to say a lawyer or a doctor should ask X question or Y question. Does she not agree?
I thank the honourable member for that intervention. I'm afraid I don't agree. I don't think we can not put in place precise legislation because we trust that everyone will do the right thing. Our job as lawmakers is to always think about the worst possible situation that could happen and legislate accordingly to protect as best as possible from that. So I would suggest that in most cases, it will absolutely, 99 cases out of 100, it will work perfectly fine and people will do their job as they're meant to. The point I'm trying to draw out here is exactly what the bill says. And what it says is required is actually very little. They are required to hear from only one of the doctors. I still don't know what hear means. I mean, exactly what content are they meant to provide? So that's the point I'm making. I think it's really important that we make legislation for the worst case situation. That is our job. I will, of course, allow you to
I'm not going to pursue the exact line of that, but the point of discussion here, and I guess the point of vote, is whether we think this proposal, which to me is robust and must hear from doctors and must hear from the patient, exceptional circumstances, with 3 professionals involved, is stronger or not from the previous drafting about a High Court, which had no such requirement. So I just wonder whether, even if she doesn't think this is perfect, whether she thinks this is surely a stronger set of safeguards and whether she'll therefore be supporting it.
Rebecca Paul.
I thank the honourable member. Again, I'm not sure I agree that that is what I'm here to do today. I think my job is to say what the strengths and the weaknesses are of the amendment proposed. And I do think the High Court judge safeguard, on the face of it, was probably a safer safeguard. I totally appreciate and value what is being attempted to be done here in terms of bringing in psychiatrists and social workers. I really, really do truly welcome that, but I do think it's come in at the wrong phase of the process, and I'm not sure we're really getting the value of that expertise at the judicial point. We would have got that value from them at the clinical stage. So Please do take it in the good faith that it's meant. I'm here, my intention is to make sure this bill is as safe as possible, and I think it's really important. I don't profess to have all the answers, but I do have questions, and I think sometimes it is useful to ask those questions because there are others here that can answer those, and I hope we will get a stronger bit of legislation from asking those questions when we as members are uncertain on whether something is the right way for us.
She's absolutely right that we are here to ask those questions, and I appreciate those questions being asked. In terms of what happens earlier on in the process, I hope she's reassured by the fact that we've now got the compulsory referral to a psychiatrist if there's doubt around capacity, and we've got specified on the face of the bill doctors consulting with other health and social care professionals to give that holistic approach earlier on in the process.
I thank the Honourable Member for that intervention, and I absolutely welcome those amendments. I do think they improve the safety of the bill. As I've mentioned before, I would have liked to see a truly multidisciplinary approach taken, because at the moment it is just that we are including something on the face of the bill, as the Honourable Lady says, where a doctor can refer, if they so wish, to another specialist. I would have liked to have seen that team pulled together and that recognised on the face of the bill. I think we heard that in oral evidence strongly. I will, of course.
I think the other point I would reiterate again is that none of that stops happening. We've heard from professionals and experts that happens. If you think about somebody who has got cancer, they will have that multidisciplinary team around them as part of their natural treatment process, and nothing in the bill stops that from happening.
I thank the Honourable Lady, and I take that point, and in an ideal world where our public services weren't under pressure, I might be more reassured. But as I myself, I'm a local councillor, I am well aware of how difficult it is to get social workers, they're spread so thin, get them involved in all of the things that they need to be involved in. So I think the Honourable Lady, she lays out very well how it should work, but I do think when I take my rose-tinted glasses off, I'm concerned that it won't work like that in the real world. So that's why I always go back to putting things on the face of the bill, because it forces it, basically. It forces that treatment. You'll be pleased to know I now come to my amendments, but I'm afraid there's 4 of them, so do bear with me. So I come to new clause 17A, which may be one of the most important amendments that I've spoken on and will speak on. This is something that I feel very passionately about. So one of the most important questions we should ask is how the panel might deal with a family member with concerns. Concerns, for instance, that a relative was being coerced. Would the family member be afforded the status of being a party to proceedings? Would they have a right to see the relevant documents before the panel? Do they have a right to be informed of a panel taking place? If they are not a party, is their status that of a witness? If they are a witness, do they have the right to observe proceedings where a panel sits in private? Do they have a right to be heard by the panel? Again, I'm asking questions. I'm not necessarily saying one way or the other what the answer to those questions should be, but these are questions I have. So none of this is laid out in the new clauses. In fact, I would suggest that in the struggle to balance autonomy with the rights of impacted others, autonomy is very much winning the fight in this bill. I was so struck yesterday by various members setting out their fears that the first a family could find out about an assisted death is when they are called upon to make the arrangements for the burial. That is an awful situation, and I strongly believe that families and loved ones should not be cut out of this process without good reason, especially when no doubt they're required to bury the person and pay for it, as I'm assuming the state isn't going to take on that responsibility. I would suggest this point on funeral arrangements and expenses is something that does need further thought on as this bill progresses. On the face of the bill, all we know the answer to those questions is that the panel may hear from and may question any other person. There is no mechanism for family members to have a right to be heard or even to submit information. That needs to be rectified. So the panel could reach its conclusions without hearing at all from the family. This is an unacceptable situation. If your mother or father or son or daughter was going in front of an assisted dying panel, you would at least want to know and be clear on your rights and the available options to you to feed into the process. And then we come to the big issue. What if a mistake is made? A relevant piece of information isn't provided to the panel by the people it hears from. My amendment seeks to help the panel avoid making the wrong decision and give time for it to be remedied before the patient is dead. When approaching scrutiny of this bill, I've always done so from the perspective of, is this law good enough for my children? Does it protect my children? And if the answer to that question is no, then it's not good enough for anyone. I think this is a really good test for lawmakers. So when considering the panel, the worst case example that comes to mind for me is, what if my child, long grown, has fallen into a relationship with an abuser? That abuser has isolated my child from me and the rest of the family. They no longer communicate with me, but I have seen and I know the abuse and I know what their partner is capable of. But the doctors don't know any of this, and of course the partner isn't going to tell the panel. There is no obligation for the panel to hear from me, even if I contact them in desperation, trying to warn them. Under new clause 21, they are not required to hear from me. I cannot even imagine the agony of not being able to intervene and share relevant information with a panel that holds my child's life in their hands. So, my amendment gives that family member or other relevant person the right to apply to the Commissioner for the panel's decision to be reconsidered. New clause 17 is already designed on that assumption. It allows for an appeal when the panel has refused an application. But the appeal process only goes in one direction. Nobody can appeal if the panel accepts the application. Only one kind of mistake can be corrected. I'm very uneasy about this. It seems to say that we are more concerned about making death possible than about preventing wrongful death. My amendment ensures that any wrong decision can be challenged, rather than just the one where an assisted death is rejected. There are problems which the panel may not see, but which others may. Take an example from Victoria, Australia, reported by the psychiatrist Professor David Kissane and carefully anonymised. He describes a communication from the spouse of an assisted dying applicant whose application has been accepted and who had the lethal substance at home. The spouse said that their adult child was applying pressure for the substance to be taken. The child, on a 3-week visit from abroad, wanted the medication taken soon, but the spouse thought that the couple might enjoy a few more months together. A direct question was asked of the patient: do you feel pressured by your child to take the medication? Perceiving that the child was being challenged, the patient denied any sense of pressure, but took medication the very next week so that the child could return overseas again. The bereaved spouse was left to struggle with an angry and complicated grief. Now, to be clear, I am not saying that this is a situation where appeal might have been upheld. What Professor Kissane's story demonstrates is that families can see things very clearly in a way that professionals, even with training, cannot see. Families know the person well. They understand their relationships. They know the subtleties of the situation.
Would you give way on that point?
I will, of course.
Thank you, Chair. Is she reassured by the fact that under the bill, coercion becomes a criminal offence with a very serious prison sentence? That's the word I'm looking for. Thank you very much. If any family members are in any doubt as to whether coercion is taking place, it's very straightforward. They go to the police.
I welcome the Honourable Lady's intervention, and I of course do welcome that point, but the point that I'm making actually is not one of coercion. The point I'm making is the subtleties in the relationships of families. So that was just to really bring to life the situation that sometimes it's families that understand the relationships and the dynamics and those pressure points. It's very, very hard for professionals to get exactly underneath that. So families, they are, in a sense, the greatest experts. The current process excludes their expertise. Under my amendment, if they had knowledge that could make the difference between life and death, they would be able to apply. And if there was a clear error in applying the eligibility criteria, the application would be reconsidered. It is true that the panel will be informed by at least one of the doctors and that it has the option of hearing from others. Perhaps the panel will always be incredibly thorough and explore every avenue, but we have to legislate for every situation, including situations which are not ideal. And we can learn a lot here from other jurisdictions. In written evidence, the academic Christopher Lyon from the University of York describes his experience in Canada. Dr. Lyons writes that his father, who was openly suicidal and had a history of mental illness, qualified for medical assistance in dying in 2021. In Dr. Lyons' words, he was classed as having a foreseeable natural death, my family was told, because he had momentarily skipped some meals at his residence and had an elevated but unremarkable white blood cell count that the doctor suggested might be an infection that, if untreated, might become lethal, despite being a common side effect of his arthritis medication. Dr. Lyons says that when informed 2 days before the event, he pushed for an urgent psychiatric assessment to be carried out. Dr. Lyon has obtained a copy and says it is full of errors. It claims he wasn't suicidal when he had a whole history of suicidality. It states he didn't think he was depressed, and yet on the list of medications there was listed antidepressants. Dr. Lyon's concerns about his father's prognosis, the assessment and other aspects of the events are widely shared, he says. After he died, the Provincial Regulatory College, police and even other assisted death clinicians suggested his death was questionable or even wholly unlawful. However, privacy law and the continuing resistance from the local health authority have so far succeeded in blocking access to his medical records necessary for a full investigation. In Ontario, meanwhile, the Chief Coroner has published a report detailing the assisted death of an anonymous patient, Mr. A. Mr. A had inflammatory bowel disease. He was unemployed, dependent on his family for housing and financial support, and struggled with alcohol and opioid misuse. He received an assisted death on the basis that his illness was advanced, irreversible, and causing intolerable suffering. According to the coroner, the family were not consulted by those involved with processing the application, even though it was recorded that the family expressed concern. Most members of the Death Review Committee thought shutting the family out was a mistake. The committee concluded engagement with family and or close relations in the MAID process should aim to be a key component of MAID practice. Now, we can hope that these were exceptional events, but these are the kinds of situations where a panel might have benefited from a family perspective, and that's the reason I cite them today.
Will she just give round?
I will, of course.
Bit more, Taz.
Very grateful to the Honourable Lady. I mean, as she heard yesterday from the member for Rother Valley, there are multiple points at which, in this new system, family could make their views known, and indeed, if they wish, they could apply very quickly for an injunction if they think something is untoward. But she's talked a lot about families knowing best. Surely it should be the dying person's choice about how best to handle their family. And what we find, certainly from the evidence overseas, is that choice about the manner and time of the death of dying people given to them also gives them the choice about how to handle their family, and particularly their children. And while she may have a particular approach, mine might be completely different, and I should have that choice. So, sorry, the point I'm making is she seems to think other family know best for me if I'm a dying person. How come she doesn't think I know best for my family?
I thank my honourable friend for that very important point. And I think it's really important that I say I don't always think family know best. And there are absolutely situations where someone absolutely rightly will want to exclude their family from it. And I totally respect that choice. What I'm saying is that there are going to be other situations where family do have something valid to input that could impact the decision making of the panel. My honourable friend also talks about an injunction. Again, that would be something I would be keen to understand more about. Maybe that's another question for the Minister as to how that works as a protection, because that may well give me some reassurance about that. And I am, as we'll go through my speech, I'm going to come on to some of the points we were discussing about judicial review in a moment as well. But the honourable friend's right, this is not easy. So this is not, I'm not saying in all situations family should be involved. I'm saying there is a balance here, and I don't think we're getting the balance right, because right now the balance is all about full autonomy. The working assumption is that that input from family must always be ignored if the patient so wants that. And I think it's a balance, and it's very difficult to set where it should sit, which is why we have such an incredibly difficult job, actually, with this bill. I will, of course.
I'm very grateful. Speaking on that point, I wonder if I could ask her a genuine question, whether she's of the view that families' views as to whether the decision is right for the individual should be considered by any panel, tribunal or judge, or whether just their eligibility under Clause 1 of this Act.
I thank the honourable member for that important point. So I think the point I'm making is that they should be listened to. So the family should have a route, and they should legally be able to provide information to the panel. Right now, they have no right to legally do that. Now, I think that most panels would take that in reality. I'd like to think, again, 99 times out of 100, a panel, if a family member contacted them saying, I've got really, important information, I'd like to think they would listen to that. But I'm legislating for that, 1 out of 100, 1 out of 1,000 cases where, for whatever reason, the panel refuses to engage with a family member. They've got a really relevant bit of information, and it leads to the death of someone, simply because the panel didn't have the right information. And this is about protecting panel members as well. If I were a panel member, I would want this process in place because it would protect me in the decision I'm making, and I would take great comfort from knowing that a family member with relevant information has a legal right to at least communicate that to the panel.
Will she give way?
I will, of course.
I'm grateful. I think that's a very helpful exchange. I'm grateful to my honourable friend. Does she agree with me that, in response to the honourable gentleman, yes, indeed, the obligation should be to help the decision maker conclude whether the eligibility has been properly met. There is no best interest consideration, much as there might be if some others of us were designing this bill. Nevertheless, the role of the family is there to enable the decision maker to conclude whether there has indeed been issues of coercion or lack of capacity, so that that decision can be properly informed, which at the moment, under the bill, our concern is that it's not.
Rebecca Paul.
I thank my honourable opponent for that. I completely agree. And actually, some of these amendments are coming out of the fact that we haven't got that best interest component in the bill. In an ideal world, I would have liked to have seen a best interest component. That would have given me some reassurance. So some of the amendments you're seeing come through today from me are of a consequence of amendments that were voted down earlier on. You wouldn't have seen these if we had taken some different decisions earlier on in the bill. I'm just trying to put the safeguards in somewhere, because I'd rather have them somewhere. And arguably whether they're in the right place or not is another question, but we've already ruled them out earlier on in the bill. So I am left in this situation. So, as I was saying, we can hope these were exceptional events, but these are the kinds of situations where a panel might have benefited from a family perspective. Or, as my amendment allows, for second thoughts from one of the assessing doctors, or any of the other people whose expertise the panel wanted to call upon. So this doesn't just protect family. I think that's the point here. This also protects the doctors that are involved. If they suddenly become aware of something, that there is another avenue in order to appeal a decision. So again, I think this is a positive thing for the coordinating doctor and the independent doctor as well, and any social workers, psychiatrists, anyone else that has been involved throughout this process. There are two additional practical benefits to this amendment, which I would like to briefly outline. First, it will resolve issues before legal disputes arise in the first place. So in Belgium, we have seen the long-running case of, I'm going to say this name wrong, Teen Nies, which has been pursued in both criminal and civil courts, with her family arguing that she did not meet the eligibility criteria for euthanasia. In Canada, a man's family has launched a legal challenge after he received medical assistance in dying while on a day pass from a psychiatric ward. They claim that he lacked mental capacity. It is all too easy to imagine similar cases coming to court here, but if there was a chance to challenge the decision earlier, it might allow families to come to terms with the decision before having to launch a legal action. Secondly, my amendment could help families come to terms with grief. There are several stories from other jurisdictions of the grief felt by relatives at being cut out of the assisted dying process. In written evidence, the National Bereavement Alliance say, and I quote, "We believe that as currently drafted, the bill overlooks the needs of families and friends. While it rightly includes safeguards to protect people against coercion, it does not include reciprocal clauses to address the health, welfare and well-being of the family and friends who will be bereaved. As drafted, the bill prioritises the autonomy of the person who is choosing to access an assisted death. This is appropriate. However, it does not mean that the bill should not also address the needs of family members and friends in relation to the decision." How to improve the bill in this respect is a complex question, but it would surely help if at least some families knew they could appeal if something went wrong. Even having the option there, even if they never came close to using it, would help them feel less powerless and less excluded from an event which might deeply affect them for the rest of their lives. When this bill was debated at second reading, the Honourable Member for Spen Valley told this House, and I quote, "If there is any evidence of coercion, the court will not approve the request, and if evidence emerges subsequently, the court order would be revoked." That was a sensible provision, but it does not seem to be in this new clause, and it's not just coercion we're worrying about. It could be any relevant information that the panel wasn't aware of when it made its decision. So James Mumby, former president of the Family Division, has written an important analysis of the new clause. He says, and I quote, "The bill is entirely silent as to how the panel is to deal with the kind of issue exemplified by the Canadian case, where the patient's partner intervened and obtained an interim injunction because of concerns about what was happening. What if the patient's partner and relatives excluded from participation in the panel process discover only after the panel has granted a certificate facts of the kind which prompted an 11th hour intervention by the Canadian judge? What are they to do?" I'm sorry, I'm in the middle of a quote, but I will in a second. "They cannot appeal. Can they somehow apply to the panel, but which is now probably funtus officio? Or can they apply to the Family Division and pray in aid the inherent jurisdiction? Or do they apply to the Administrative Court by way of judicial review? Who knows? And the bill does not tell us." I will, of course, give way.
I thank the Honourable Lady for giving way. I just wanted to she brings up legal cases, and she's pointed out a few different ones around the world. I just wondered if she was aware of a case that's going on in Spain at the moment, where a family member has brought out is challenging his daughter's wish to have an assisted death there. And that's been funded by religious groups, Christian groups, and it's not actually through the parent, it's him being led. He's had that option and that ability to raise it, and then it's been funded and hijacked by outside groups. So how would her amendment, and how would she see that we would protect against that sort of thing?
I thank the Honourable Member for that, and I think this is a really important opportunity to share all of these examples. I have to be entirely honest, I'm not sure I see the relevance of how it's been funded, and I can't speak on behalf of that person. And actually, as I'm going to come to, I'm going to talk about some of the inequalities that come from this. There will be people, we'll get to it on the judicial review point, that in order to challenge a decision need to rely on legal aid. So actually we are in danger, if we don't get this right, of creating a situation where poor families can't appeal and rich families can, which could give rise to the situation, the less than ideal situation that you've raised. So I would suggest if we get this right and make sure that an appeal process is available on an equal basis to everyone in this country, that would prevent that kind of situation that the Honourable gentleman has just raised. And I thank him for that, because I think you've helped support the case for my amendment.
Would she just give way? Would she just give way?
I will, of course, give way.
I have to say I'm growing in concern about her amendment, because we've talked in the past about policing the conversation, the process, to the extent that it becomes guarded. But if her amendment were in place, say for example, in my family, I had a strong conviction, long-standing conviction, that I wanted to have assisted dying if I was an extremist, but I had a child who I knew was violently anti-assisted dying, and there was this possibility of appeal. Surely my tendency would actually to keep my disease and diagnosis and approach to the system secret from that person. And that actually, by opening this door to effectively this formal door, you're actually encouraging me to conceal the process from a family member who I know may object. Now, particularly in the light of the fact that we heard from overseas experience, forgive me, Sir Roger, that coercion very often comes the other way, more often than not, and certainly that's what they see in Australia, where families try and persuade somebody not to do it. And I'm concerned that, albeit I think she has a good motivation for her procedure, that she actually might produce the opposite effect and drive people into secrecy.
Rebecca Paul.
I thank my honourable friend for that alternative perspective. I think I would just set out that the appeal process is only valid if there is new information, relevant information the panel didn't have. So it's not going to for someone who is absolutely eligible. You know, there's nothing that's been excluded from the process that would change their eligibility. There's nothing to worry about here. So I'm not sure that I concur that it would prevent sharing that information. But I do think it provides an important protection when a bit of relevant information hasn't been shared by the panel. And I think the greater harm is with that. You know, quite often what we're doing, we're trying to, it's scales, isn't it? We're trying to weigh up, we're trying to make sure the harms don't outweigh the benefits. So I honestly believe this amendment would help balance those scales a little better. I will, of course.
Thank you. And just further to that point, I mean, the scenario that our right honourable friend suggests implies that the patient has no faith in the commissioner, in the panel, because they would then be concluding they didn't want to go through the formal process of an assisted death and to explain it to their relatives because they fear that the panel's decision might be overturned on application by their relative. So the objection is predicated on a lack of faith in the process which is being decided. If we're to have confidence in this process, we should trust that people should expect that it should work properly. And I think there's nothing wrong with giving a family member the right to make an application to the commission, to the panel, which might, or the commissioner, which might then, which they would have absolute every right to overturn if they conclude that the original decision was valid.
Rebecca Paul.
I thank my honourable friend for that intervention, and I completely agree. And it's often the nature of these things. As I was preparing this speech for today, one of the amendments I now wish I'd put in is actually just the legal requirement for family to be able to feed into the panel, just share information. And maybe that's something that can be picked up at a later stage, because as the nature of these things is, as we debate, as we think about these things in detail, other ideas come through.
Would she give way?
I will, of course, give way.
She mentioned a few moments ago that the family would only make such an appeal if there was new information, but it doesn't say that in the amendment, and there's no explanatory statement with the amendment. So can she just clarify what she means by that?
I thank the honourable lady for that. Let's have a look. So it basically comes into subsection 2. So the Commissioner will allow the application for reconsideration if the panel's decision was wrong or unjust. So implied within that is for it to be wrong, there is missing information. So missing information is an example. There will be other things that would allow an appeal, but I think the obvious one, the most likely one in this instance would be a certain bit of information that hasn't been shared. But again, what I am very open to doing, I'm not saying the amendment is perfect in any way, and as we know with a private members' bill process, it's set out in guidance clearly that amendments aren't necessarily going to be drafted perfectly, and it's incumbent upon the government to take the spirit of what is intended and get the clause into an appropriate place in order to deliver that. So I'm very, very happy to work with government in terms of ensuring that the wording works and that it's clear, because I think the Honourable Lady may be making the point that it's not clear. So very happy to work in any way to improve that clarity.
Will she give way, just briefly? I'm very sorry.
I
just wanted to respond to the point made by the Honourable Gentleman through her, Sir Roger. I mean, it's not necessarily that somebody may not have faith in the panel, but if, say, for example, they have a relative who's driven by a very strong religious faith, who wants to create some form of delay in the system, because they just want to put off the awful day, even if a commissioner was to take an application and then decide it wasn't valid, that would inject delay in what is naturally a time-limited process. It also, as I say, it's not necessarily that they wouldn't have faith in the panel, in my view, it's that they want to retain the right to handle their family themselves and to have the choice about how they've handled their family themselves. And if you are effectively, the state is deciding how the family should be handled rather than the dying person, you are naturally giving them an incentive to keep this thing quiet until I'm ready to tell my family, which may well be well towards the end of the process. Now, as the Honourable Gentleman of Rother Valley has said, there are multiple points at which family can intervene if they know. And my concern is that this kind of what's the word we've been using, embroidery, actually drives people in the opposite direction to that which she wants to achieve.
I thank my honourable friend for raising that point, because it gives me a wonderful opportunity to draw everyone's attention to subsection 3, which says the Commissioner may consider the application without a hearing if they consider it in the interest of justice to dispense with a hearing, because you are absolutely right. Time is of the essence, and there will be situations where actually it is right that it moves as quickly as possible. So I hope that goes some way to reassuring you that I am trying to come up with amendments that are balanced, because I am aware that, you know, we've got the two different examples here, and I am genuinely trying to make sure that I don't make it harder for those genuine cases. So I totally understand how important it is, you know, if they're, you know, in a lot of pain and suffering for all the reasons you've set out. So I hope I'm getting the balance right. But like I say, always happy to have further discussions. Sir James Mumby was one of the first to criticise the High Court safeguard, and the Honourable Member for Spen Valley has said she has taken those criticisms on board. His criticism of the panel seems similarly acute. I hope the committee will agree that this amendment answers a real need and recognises the important role of family in the death of a loved one in most situations, except not in all. It has a profound and long-lasting impact on them too, and their needs should not be entirely disregarded in the name of autonomy. The Honourable Member for Rother Valley yesterday gave a very powerful speech on this, setting out that this amendment is not required as any decision could be judicially reviewed. Now, I'm not qualified to opine on whether judicial review would be relevant with this panel, but I look forward to the Minister covering this in her closing remarks, as we need to be clear on this front. Judicial reviews are a challenge to the way in which a decision has been made, rather than the rights and the wrongs of the conclusion reached. It's important that this is understood, so it just checks that the process was followed, not whether the right decision was made. And that is why our role here is so important in setting what the process is. So if this new clause remains unchanged and there is no requirement for a panel to accept relevant evidence from a family member, then there is no avenue for appeal under judicial review when such information isn't taken into consideration when making the decision, because the process was followed. Our role here on this committee is a heavy one in terms of getting this right and setting the process for judicial review to work in the way that it should. What we do have in this new clause, however, is an appeal process on the face of the bill for when the panel wrongfully turns down an application, but not for when they wrongfully approve. Why is that if judicial review is available and suitable? I suspect it's because, as the member is aware, that judicial review is not the best way to do it and is a long, onerous process involving application for the permission, securing of legal aid in some situations, which again is fraught with difficulties. So I say gently to the member, if judicial review isn't suitable when the panel has wrongfully turned down an application, then why is it suitable when they have wrongfully approved someone for an assisted death? So I think it is clear that my amendment is needed as a safeguard to prevent wrongful deaths under this Act. It is a helpful safeguard. No panel would ever want to see someone assisted to die when they shouldn't have because they didn't have all the information. I would suggest that this safeguard will actually help secure panel members, as they will feel reassured that this process is in place to help avoid mistakes. If my amendment doesn't pass and wrongful approvals do have to rely on judicial review to remedy, then I would suggest that the impact assessment will need to take into account the likely impact on socio-economic groups that rely on legal aid to fund, as I suspect they will find themselves with no avenue at all to appeal due to lack of funds. I don't think any of us want to see a two-tier system where rich families can intervene and poor families can't. Moving on to new clause 21C. I will, of course, give way on the...
I'm very grateful. I was challenged in her speech, quite fairly and rightly. But the difference is that if you have a right to appeal in the internal process by a family member, then that family member would have to be a party in the original proceedings or in the original hearing. And the whole point of the panel is this is about a person coming to the panel with their application. family have the right to put information before the panel, but not the right to make their case to the panel, because their views on the application are not relevant. Information they might have is relevant, but their views aren't. And that's why there is a disparity between the person being able to appeal internally against refusal of their application and third parties being able to, having to take other routes. So I hope that offers some clarity as to why I'm comfortable with the difference between the two. And I just want to reassure her that that is something that I've thought about long and hard as well.
I thank the honourable member for that, and I would just clarify back that there is no legal right for a family to provide information to the panel currently, and that's part of the issue. I now come to my amendment, new clause 21C. New clause 21 includes, amongst other things, that the panel's function is to determine whether it is satisfied that the person has capacity, that they have a clear, settled and informed wish to end their life, and that they have not been coerced or pressured. But it is not entirely clear what satisfied means in this new clause. My amendment assumes that it means on a balance of probabilities, as in a civil court. As I understand it, the leading case on the meaning of satisfied is a House of Lords case from 1964, in which the court held that satisfied meant on the balance of probabilities rather than the tougher test of beyond reasonable doubt. In a later amendment, I will propose that we adopt that tougher standard, but this amendment assumes that the current wording will stand. We've already established in lengthy debate that the capacity bar is low, in my view, as the doctor only needs to be 51% sure. And on the clear, settled and informed wish and coercion test, the standard only is to the best of the doctor's knowledge, not a particularly high bar to meet. So we are applying a low bar to a low bar. That certainly leaves us with a highly accessible process, but I would suggest that is not a positive or safe thing. My amendment brings a further safeguard. As I've said several times before, I'd have preferred these safeguards went in at clauses 1 to 3. But as they weren't accepted, I'm forced to try and put them in here, as it's better to have them than not at all. My amendment gives the panel the ability to decide that if there is a real risk that the criteria have not been met, to pause and make further inquiries. It means they are not obliged to give a decision that day. They are obliged to look into it further, to ask for more testimony, to request more documents, to consult experts. As I've mentioned in a previous sitting, the real risk test is taken from the jurisprudence of the European Court of Human Rights. Doctors will already be familiar with this. They are already required under the Human Rights Act to assess when there is a real risk of suicide. This is not then a strange novelty. It was objected before that introducing a real risk test to the doctor's assessments would complicate matters, but the panel stage is a distinct stage with a distinct set of rules, and I hope this amendment will be seen not as introducing a complication, but as filling a gap, particularly given that this stage is meant to be more akin to a judicial stage. Those difficult situations will not necessarily be as rare as we hoped. So to stay with the various examples we've been talking about on coercive control, time and time again, those with decades of experience working with the most vulnerable have warned us what this bill can mean. So Jane Monckton-Smith, one of the leading academics in this area, has said, and I quote, "Unless we do take this incredibly seriously, this bill is going to be the worst thing potentially that we've ever done to domestic abuse victims." The consultant clinical psychologist Sue Smith, who specialises in cancer and palliative care, says the following in written evidence. I will quote it at length because it brings out vividly the scale of the risk here. And I quote, "In my clinical experience working with people who have cancer, a cancer diagnosis and treatment effects can amplify CCB, so coercive and controlling behaviour. A woman asking for her needs to be seen and met alongside her increased physical and psychological vulnerability creates a change within the couple which can lead to violent acts or CCB. The seriousness of the cancer diagnosis may be systematically and actively denied or minimised. Claims can be made by the male partner that she is attention-seeking or she is accused of making up the effects of treatment and can be left isolated and alone when in physical need, e.g. managing treatment effects like nausea or pain that restrict the ability to wash, dress, and where she's reliant on others for help. At the same time, a male partner may also state, you are better off dead anyway, your children don't care, and no one else in your life cares about whether you die. They may also threaten to leave. This pattern is extremely confusing, harmful, and threatening. It continues over time, and a woman learns to doubt her reality and experience and is extremely isolated. This can lead to heightened anxiety, hopelessness, helplessness, and abject despair, which can lead to a person wishing they were dead. The confidence and ability to know what one needs and wants is severely compromised when her reality is continually minimised or denied and will impact informed decision-making. We can hope that the existing safeguards will catch some of those cases, absolutely, but they won't catch all cases. So my amendment would go a little way to improving the safeguards. Right. Getting there. Amendment 21A, again, so Amendment 21A tries to pin down a missing detail, namely, what is the standard by which the panel makes its decision? When in a criminal trial, a jury is sent away to consider its verdict. The members of the jury know that they must be certain of the defendant's guilt beyond reasonable doubt. It is not enough that they think it is likely on balance. It is not enough that they have an opinion which they can justify with good reasons. It must meet a high threshold. Why is there such a high standard? It's because we have to be sure about the decision given the grave consequences. And now we are considering a similar question. What is the right standard for a decision which will make the difference between life and death? Turning to new clause 21, subsection 2 and 6, we are told that the panel must be satisfied that the eligibility criteria have been met. The word satisfied is doing a lot of heavy lifting in this bill. If a question subsequently comes to court, as it has in Belgium, where there was a wrongful assisted suicide, we'll be asking that court to rule whether the panel should have been satisfied, which raises the obvious question, and one which my amendment is designed to answer. What does satisfied mean? Let me turn to a real-life example. In a famous case in Oregon, an elderly woman called Kate Cheney sought assisted suicide. She had a terminal cancer diagnosis. She also had dementia, and so was referred to a psychiatrist to see if she had capacity. She was accompanied to the appointment with the psychiatrist by her daughter, Erica, who seemed extremely assertive about the assisted death. Kate Cheney denied that she was being pressured. However, the psychiatrist noticed that the daughter was coaching her mother. The psychiatrist wrote in his report, referring to Kate, she does not seem to be explicitly pushing for this. He concluded that she did not have capacity to make the decision. The daughter was, in her own words, incensed that the psychiatrist was casting such a judgment on her mother. Kate applied for a second opinion and was assessed by a clinical psychologist. He found that Kate did have capacity, but he added that her choices may be influenced by her family's wishes and her daughter, Erica, may be somewhat coercive. Nevertheless, he gave the green light to the application and Kate received the go-ahead. I would ask members of the committee whether they would be satisfied that Kate Cheney was eligible for an assisted death. Are members confident that colleagues would share the same judgment about being satisfied? And can members be sure that every social worker, legal figure and psychiatrist would be satisfied in the same direction? After all, the psychiatrists in Oregon themselves were divided on this. In written evidence, the most experienced clinicians have urged us to recognise that abuse is difficult to pick up. Sarah Grove, a consultant in palliative medicine, says, and I quote, "Over my years in practice, I have witnessed families acting for financial gain and not in their loved one's best interests. But in this kind of situation, this has always been impossible to prove." And Catherine Myers, a retired palliative medicine consultant, says, and I quote, "I have seen coercion in the context of decision-making around the best place of care for patients and of money and property. Perpetrators are usually family members," Dr. Myers writes. She goes on to say, "Occasionally it has been overt and easy to detect, for example, threatening or manipulative words or actions. Most frequently it has been very subtle, one might even say gentle. It can take skilled clinical nurse specialists, highly trained in communication skills and in detecting coercion, who know the person well and who have a relationship of trust with them, several conversations over several days, if not weeks, to uncover that coercion has occurred. In this kind of case, with limited time, the panel may not be certain whether to give the green light to an application. That uncertainty will be even greater if they do not know what evidential standard to employ. My amendment would clarify this grey area. It would bring in a standard which has been tried and tested and is well understood. To be clear, beyond reasonable doubt merely means that the panel is sure. The courts have said the two phrases are equivalent, so does the Judicial College in its guide for judges. the Crown Court Compendium. And I quote, "What is required is a clear instruction to the jury that they have to be satisfied so that they are sure, if an advocate has referred to beyond reasonable doubt. The jury should be told that this means the same thing as being sure." And the Crown Prosecution Service says, "The magistrate or district judge in a magistrate's court or the jury in a Crown Court must be sure that the defendant is guilty. Sometimes you'll hear this described as sure beyond a reasonable doubt or satisfied so you are sure." Importantly, the word satisfied by itself is not enough. Juries must be not just satisfied, but satisfied so you are sure. This would be an equally strong wording. My amendment opts for beyond a reasonable doubt because it is a better known phrase and more widely understood than satisfied so you are sure. I do not want to get too hung up on which of these phrases to use. The point is to adopt the tried and tested standard which has worked in the courts. We want this bill to have the highest standards and to protect people. This amendment would help to achieve that. Oh, you'll all be delighted to know I'm on the last one. I will, of course.
I'm very grateful. I know that the Honourable Member has been on our feet for some time. I just want to explore the difference between what a jury is doing and what this panel is doing. Let's, for example, consider the issue of coercion. So there is no evidence that the person is being coerced in any way. But of course, the panel has not asked everyone in that person's life. They haven't heard evidence from everyone. There's no factual matrix that they are determining what has happened or what has not happened. Can the panel sit there and say, we are sure? Or do you think they would have to investigate all the circumstances of that person's life, interview everyone that is in and around their social circle to be sure that they haven't been coerced? Can you see why, as I set out in my speech, the beyond reasonable doubt burden is not appropriate for the task of this panel?
First of all, can I gently again remind members that you means me?
Forgive me, Chair.
Please refer to the Honourable Lady. Rebecca.
I thank the Honourable Member for sharing that. I think it's really useful to have these debates and conversations. But I would suggest they need to be sure off the back of the information that they've been given and the witness testimony, which then goes back to why it's so important to make sure that we've got that coverage and we've got the right things feeding into the panel so that the panel can get it to that high threshold. I'm afraid I would expect it to be at court level, given the huge, significant ramifications of this decision for that person. I will, of course, give way.
Thank the Honourable Lady. She's making a very powerful point. Would she also, and I wonder whether it's about, so jury trials, and the point the Honourable Member has made, when we do have criminal trials and jury trials, they don't go through every single thing in somebody's life. It's relation to the actual act, the criminality itself, and what is relative to that criminal act. That doesn't mean to say they tread through a whole person's life.
I thank the Honourable Member for that, and yes, and she very eloquently explains exactly the point I was trying to make. I think that's absolutely right. Clearly, we don't expect a panel to pore over everything. They can only be sure based on the evidence put before them. So again, I reiterate, that's why it's really important that all of the right and relevant information can be fed into them in order to get a good, robust, solid decision. So, new clause 21B. Okay, you'll all be relieved to know that this is my last amendment. It puts in an additional mechanism to the panel for not granting an application when there are particular circumstances which makes it inappropriate. I don't think many in the committee are going to like this amendment. I would make the point again that in an ideal world there would have been a best interest clause or something similar in the bill that protects patients from opting for assisted dying due to some other perfectly solvable challenge in their life, like being homeless. But given our amendments weren't accepted, I am putting this forward again as a responsibility of the panel, given their oversight role. And this is likely where the role of the social worker on the panel can play a really important part, actually. So in Ontario, assisted dying is monitored by a team of nurse coroner investigators who review every reported death. The state has also established a death review committee whose recent report shows some of the difficulties for a panel making its decision. So a patient referred to as Ms. B successfully applied for an assisted death. She suffered from multiple chemical sensitivity syndrome, which made it difficult for her to find appropriate accommodation. The report found that, and I'll quote, as a result of her housing situation and conditions necessary to address her multiple chemical sensitivity syndrome, Ms. B experienced social isolation, which greatly contributed to her suffering, and requests were made. In other words, this could be seen as assisted dying as a solution for a housing problem. This request split the Death Review Committee, and I would just say this bill is very different. You know, this process is different to MAID. I do just want to make that really, really clear, as I'm just trying to make the point about other factors. This request split the Death Review Committee. According to the report, some members of the committee, and I quote, cautioned that a social issue, housing, was at the forefront of this request, so it should not have resulted in her death. Others disagreed. And I quote, consensus was not achieved amongst committee members about whether Ms. B was eligible. This bill is different to that used in Canada, really different, because Canada requires an applicant to be facing unbearable suffering that cannot be relieved. The bill before us requires a terminal diagnosis, so it doesn't open up the question of other kinds of suffering and whether they can be relieved. But this bill will certainly confront the panel with the same kind of dilemma. What should be done when an applicant wants an assisted death, not because of illness, but because of personal vulnerability or social issues, because of housing problems, for instance? They will know that if that person's problems with housing, say, or some other crisis were resolved, that the desire for an assisted death might diminish or even evaporate. And they will have to decide whether, nevertheless, to issue a certificate conferring eligibility for assisted death. I will, of course,
I might have misheard her there, but I believe she said, Chair, that what happens when a patient asks for assisted death not as a result of illness? Well, if that was the case, then they just wouldn't fall under the criteria of the bill.
I thank the honourable member for that. So I'm making the point that they are, so they fit the diagnosis, they are terminally unwell, but actually it's the fact that they've got nowhere to live that's actually really driving the decision rather than the terminal illness is the point I'm trying to make. My apologies if that was not clear. Or take the case in Oregon of Barbara Wagner, who had recurring lung cancer. She had been prescribed a drug, Tarceva, which had an excellent record. It increased patients' 1-year survival rate by 45%. Oregon's state Medi-Aid provider sent Wagner a letter saying that her insurance plan would not cover the drug, but would cover other options, including assisted dying. Wagner said, I got a letter in the mail that basically said, if you want to take the pills, we will help you get that from the doctor, and we will stand there and watch you die, but we won't give you the medication to live. They're her own words, they're not my words. Recently in Australia, similar cases have been reported of people choosing assisted dying because they were put on too long a waiting list for home care package. One man said of her mother, her pride wouldn't allow any of her boys to take care of her or to bathe her, so she got approved for the assisted dying and actually a few months ago proceeded with it. There are many other situations where everyone would benefit from the panel having a broader discretion. Think of one of the cases I talked about earlier, and I have done through the various sessions we had, where somebody appears to be a possible victim of coercion. Or think of a case where someone with diabetes, for instance, wishes to bring themselves within the 6-month definition by stopping treatment. Or someone with anorexia bringing themselves within the definition by stopping eating and drinking. We know that the capacitive safeguard would not defend them, in my view. The courts have found that people have capacity to refuse life-saving treatment even if their decision is strongly influenced by other factors. Honourable members may worry that giving the panel discretion is too open-ended, but the truth is that in our legal system, discretion is the norm. Whether in sentencing guidelines or in custody cases, the law nearly always recognises that sometimes a general rule has to be departed from. If the panel are compelled to make the decisions only by a checklist with no other option, the bill is saying that the panel is less trustworthy than the courts. If this panel is to be a safeguard, we should be clear how it functions. It needs to be open to correcting mistakes. It needs to have a clear standard of proof which will protect people and not just hastily steer them towards assisted death. And it needs a wide discretion if it is truly to be more than a tick box exercise. I hope the committee will agree and support these amendments. And I will now sit down. Thank you.
Order. Order. Just before we... Order. Thank you. Thank you very much. Just before we continue, it's open to any member to speak more than once in a debate, as you know. Now Shah has indicated to me that because of the size of the groupings of these amendments, she wishes to speak not once but 3 times. But she intends to break those comments down into bite-sized chunks for that reason, because of the complexity of what we're discussing. I draw that to the members' attention because it's possibly worth putting a marker down now in case anybody else feels the same way. So, now Shah.
Thank you, Chair. It's an honour to follow the honourable member. I think she now takes a record for have stood on her feet the longest in this bill committee.
Oh no, sure.
Sorry? Well, you beat mine for sure. And I want to, Chair, if I may, speak to her amendment NC 17A, if I may, and it will be brief, I assure you, in comparison to what the early amendments I was talking about. I would also like to acknowledge yesterday by my honourable friend for Ipswich, and I disagreed over a point of detail. He was in fact right and I was wrong. And as he said, there is a provision in new Schedule 1, subsection 4, which does allow the Secretary of State to dismiss the VAT Commissioner if the circumstances merit it. Whilst I still maintain my position that it is too much power given to a single person, I thank my honourable friend both for pointing this out and the courteous way in which he did so. The honourable member for Reigate has spoken very eloquently in defence of her amendment. Just to recap, new clause 17, which is proposed by the bill's sponsor, my honourable friend for Spen Valley, would allow the person seeking assisted death to appeal to the Commissioner if the panel refused their request. But new clause 17 would not allow any other person to lodge such an appeal. By contrast, if NC 17A is adopted, then several other parties would be able to lodge such an appeal. There are 2 doctors who took part in the process, the applicant's next of kin or their relatives, and anyone who took part in the proceedings before the panel or gave evidence to the panel. Let me acknowledge that there are genuine arguments against accepting the honourable member's amendment, and I have heard and listened to them in detail and given them sincere thought. Of the family members who might appeal against a decision could perhaps have little or no contact with the person that they said they were appealing on behalf of. And I note the honourable member for Harrogate and Knaresborough made very honest and personal intervention on that subject yesterday. I accept that this is indeed a real possibility. Families are complicated, as we all know. There is also the likelihood that allowing more people to appeal against a decision by a panel for or against an assisted death could mean that the Commissioner would have to have considerably more resources. Otherwise, it would be very likely that appeals would not be heard within a reasonable... It could be that they're not heard within a reasonable period. These are genuine arguments, Chair. But there is also equally strong alternative arguments. If this bill passes, we simply do not know how many coercive or abusive people will seek to drive others towards assisted death. And at the current rate, the last figures that I had, there were only 4% of prosecutions under the honourable member referred to, the sponsoring member referred to coercion being a criminal offence. There are only 4% have actually been convicted. If this bill passes, we simply don't know how many will seek to drive others towards assisted death. But it is worth noting that many people with experience in this area are very concerned about the possibility. We don't know how many people will opt for assisted death because their need for palliative care needs or social care will not be met. Again, many people who have had first-hand experience in this field are extremely concerned about this, and I've referred to this extensively in previous speeches. We also don't know how many people will opt for assisted death, partly because they don't want to be a burden on their loved ones. We don't know how many of those loved ones would be, in fact, be ready to care for the person who felt like a burden. And neither do we know what safeguards, if any, will prove effective against any of these dangers. But one thing we do know is that allowing people who are related to those seeking assisted death or those who have cared for them could bring those dangers to light. a family member, a GP, or even a paid carer may have seen someone come under coercive control. As new clause 17 stands, they might feel that the panel had made a terrible mistake in ignoring the evidence on this. The Honourable Member for Reigate's amendment would give those people the chance to bring their evidence before the Commissioner. And I have to say that as it stands, new clause 17 seems to make some fairly odd assumptions. It allows an appeal if the applicant's request for assisted death is turned down. So that means my honourable friend for Spen Valley acknowledges that the panels may on occasion get things wrong. But the right of appeal is only one way. That seems extremely odd. It surely cannot be the case that the panels may get things wrong when they turn down a request for assisted dying, but are always right when they accept those requests. There surely needs to be an amendment that allows people with knowledge of the situation to appeal if they think the panel has made a mistake in allowing assisted death. And for that purpose, this amendment would also reduce some of the dangers that we first face. And I urge honourable members for this purpose to support this amendment.
Daniel Francis.
Thank you, Chair. It's a pleasure to serve under your chairship, and I'll speak, if I may, to new clauses 14, 15, 16, 17, 21, new Schedule 1, 2, and amendments 371, 372, 373, 377, 378, 381, 388, 390 and 391. But most probably not as long as the member for Reigate spoke, I can assure you. So yesterday, my honourable friend from Spen Valley referred to the Law Society and their neutral position on these new clauses and new schedules. I won't read out all 4 pages of their most recent submission on the matter, but of course, while they are neutral, they do continue to have a number of concerns and queries about those new clauses and schedules, and I will just read out what those headlines are. They remain concerned about the role of the layer of review, whether it would be accessible and workable for people seeking assistance and the resourcing required. They query that, or they seek clarification on the nature of the functions that will be exercised by the Commissioner and by panels. They still seek clarity on how panels will deal with cases, and they ask that we consider where lawyers may need to play a role and the availability of legal aid. And of course, we've touched on that matter this morning, Chair. So while I accept that was used in evidence on the other side of the argument yesterday, and they are neutral, I could have read all 4 pages of their response if I really wanted, but you know, that is their position, Chair. So I will be speaking to oppose some clauses, to raise concerns about others, including some of the new clause amendments moved by my friend from Spen Valley. And what the new clauses and amendments do, as we've heard, is to replace the High Court judge mechanism of the original bill with a 3-person panel. And again, as was said yesterday, that changes the bill fundamentally from what the House agreed at the second reading last November. The panel will consist of a consultant psychiatrist, a social worker and a legal member who'd chair that panel. And I concur with comments that have been made that would be helpful for those individuals to be involved earlier in the process. We've heard several concerns raised, however, about the High Court judge mechanism in the evidence we've received. And while I do accept that the new panel mechanism would address some of those concerns, it would leave some untouched, and in some cases it could make the position worse. I will make one point at the beginning of the remarks, that we did ask witnesses in our oral evidence whether and how the High Court judge system would work. And some of them said that they didn't believe it would, and I do credit my friend from Spen Valley for listening to that point, but clearly the problem and predicament we now have is we weren't able to speak to and seek oral evidence on the arrangement that's now before us, on the panel. And clearly a large amount of the written evidence had already been submitted before that stage. And clearly, if we'd, I will come to this again later, but if we'd gone through a normal process, and I accept it's not a government bill, but through a government bill mechanism, we wouldn't be in that position at this stage. We are now, as a group of 23 of us, debating these schedules and clauses before the bill goes back to report stage, but not having really, well, certainly not having any oral evidence on what's before us, and a lack of written evidence, I would argue. The panel system does have complications, and of course it will be of life and death importance. And as I've said, we should have been able to ask witnesses about how and whether a system could work, and we haven't been able to do that. If it had been a government bill, the civil service would have undertaken months of consultation with experts and stakeholders, and as we've commented on previously, of course, we also would have had a number of documents, including the Equality Impact Assessment and the Human Rights Assessment. And they would have been published by the civil service for us to have considered. We're dealing with this complex matter, as I've said, in a very different way to what we would with a government bill, and I'll now turn to some queries and some concerns about what's before us. Firstly, should people be giving evidence? Absolutely.
Danny Kruger.
Before he moves on, thank you, sir. Before he moves on, I just want to really reiterate the value of the point the Honourable Member is making. This is an enormous change to the bill, it totally transforms it. We didn't have the opportunity to hear evidence on it. Is he also aware that many of the distinguished people who gave evidence against the judicial stage, which has now been scrapped, have not endorsed the proposal to change it, and in fact some of them are equally opposed to the new proposal. So we have not had confirmation that this is the right system, and we didn't get the opportunity to hear proper evidence on it.
Daniel Francis.
Thank you, Chair. Yeah, yes, I'm aware of some of those submissions from those individuals, and clearly, and I'll turn to this, even some people who were in support of the changes recommended changes which aren't now incorporated. So firstly, I would argue, should people be giving evidence to the panels be doing so under oath? You know, in my years as a local councillor, 20 long years, I gave evidence under oath to a health and safety executive investigation about the demolition of a building. I would say the demolition of a building and this matter are two very different matters, and therefore, I would query why that evidence isn't being given under oath.
Do you agree?
Absolutely.
I thank the honourable gentleman for giving way the start of a thoughtful speech. I wonder if you'd had a chance to consider the situation regarding mental health tribunals that they made yesterday, which usually do not take evidence under oath, and they clearly make decisions regarding sections and deprivations of liberty, very, very serious decisions, not invoking oath-taking powers.
Thank you, Chair. And I accept what my honourable friend says, but there are, differences in opinion. I would say that, and I accept that's a very serious matter, but I would accept equally that a matter of life or death is more serious. And as I say, there are processes that we know. As I say, I gave evidence under oath about the demolition of a building and whether someone had carried out the correct health and safety regulations, and yet we wouldn't be doing so. In this case, I'll give way to my honourable friend.
I thank the honourable member for giving way, and in relation to the intervention, my understanding is that at a mental health tribunal, a person would have entitlement to legal representation, and that legal representation would be an officer of the court or a lawyer indeed, and the bar is very different. So I think does he agree with me that actually it's not the right, it's like comparison of an apple and a pear, so to speak.
Thank you, Chair. Indeed, and these are complex matters that I will turn to, but there are these comparisons, and again we've heard a lot about Spain, and I'll refer to that briefly later. But again, Spain has a very different legal process to us. Anyway, I'll return to my comments. So, on the issue of evidence under oath, currently, of course, you wouldn't have to do so. And as I've said, the matters discussed in the panel are as important a matter as I think that there can be. People, in my opinion, should be giving evidence under the same standards they do in a civil or criminal court. My second concern relates to the procedures for investigating any doubts the panels may have. Again, we've heard some of that, Chair. The panel must hear from at least one doctor and from the applicant under this new set of proposals. They must read the two doctors' statements and the applicant's declaration, and then they can decide to ask questions of the applicant or one of both the doctors. The panel can also hear from and ask questions of any other person. but one question to ask is, how is the panel going to know which people to talk to? Will the panel be asking the right questions of applicants? Applicants will have different circumstances, clearly, in different cases. And you could also argue, will those professionals still be skilled investigators? Although I do accept the evidence we had regarding the skills those people do have and that they bring. It's not clear to me whether they will be acting in a quasi-judicial way, and we've heard it isn't going to be the adversarial system. And while I can see the problems about creating an adversarial system for the panel, and again we've turned to this this morning, there are other systems in other countries where that is allowed, so that the individual has both that exists and a different appeal system exists. On the third point, which is the standard of proof, if the panel finds matters that worries it but doesn't find actual evidence of coercion, then it's not clear to me what it does. They could, so the panel could find that a patient is qualified for assisted dying on the balance of probabilities, and then approves that request. So 3 members of the panel could decide that a patient is on the balance of probabilities free to make a decision, and I would argue, people have heard my concerns about other issues on that capacity, whether that's correct. And again, we did talk yesterday about how decisions are made in new Schedule 2, and particularly Clause 5 or Part 5 of that, and I think there are differing views around the table here, let me say, about subsection 2, talking about a majority vote and how that may then align with subsection 3 of that. My fourth concern is there's no provision made in the new clause amendments for how the panels will deal with people with learning disabilities. Again, there may be a further amendment to come on that matter, and we've accepted one amendment on training on that matter, but within the bill as it's written, I accept again there is training of those individuals, but I would have concerns about how that could be judged. We've heard, and again I referred to yesterday, about how people with learning disabilities could go through this process with no support from friends or families, and would then be being presented to the panel. And I will put my question that I've put in consistently, under the Mental Capacity Act 2005, and the regulations within that, and within the code of practice, would the panel have to assist the person in making a decision? Because that's what, in my mind, again, the Mental Capacity Act states, that if someone requires help to make that decision, that individuals who have that power should help them to do so. Again, I'm very well aware that people with learning disabilities, that there are wide differences in how professionals talk to and listen to them and interpret some of their communication skills. I know that firsthand on a day-to-day basis. And again, I think the bill should set out best practice in this field. It should do that from the start, so that we don't see discrepancies between how panels are undertaking their work with learning disabilities. Because I don't think I need to spell out how a bad decision in this field could literally lead someone choosing assisted death to a place where others may not want to be. We've talked about appeals, and the fifth area relates to appeals, that they can only go one way. A person whose application for assisted death, which is rejected, can appeal to the Voluntary Assisted Dying Commissioner, and the Commissioner can then either uphold the decision or allow the person to have an assisted death. And we've discussed what happens if a person who knows that person applying for assisted death appears in the case and has grounds for concern. In answer yesterday to me, we've discussed judicial review, but again we've discussed today about the legal means of people wishing to seek a judicial review, and of course that would cause grave concerns for me. Under the bill as it's written, the person that's known to the person seeking assisted death cannot appeal against any decision. And again, I've heard that debate and discussion this morning on the Rygate's amendments. But the bill says that the panel can choose to hear from any person who's a relevant connection, but there doesn't appear to be a mechanism for someone who has concerns to apply to register those concerns with the panel. And in the oral evidence we received, we did hear concerns from both Sir Nicholas Mostyn and Alex Wright-Keane that both sides should have the right of appeal. And so we've heard that from a legal background from both supporters, and I hear that Alex Wright-Keane is referred to as an objector. I think he would say he's neutral in the process, but from people who have differing views about the process in their oral evidence, said to us that both sides should have the right to appeal. Absolutely.
That's sharp.
I thank the honourable member. He's made some very important points. I wonder if the member is aware that Professor Mark Elliott, one of the UK's leading professors of public law and the former chair of Cambridge Law Faculty, has said the asymmetrical nature of appeals under the bill is striking. At best, suggestion that judicial review is an adequate substitute for families who wish to challenge decisions indicates a fundamental misapprehension about the nature of JR. And on the suggestion that injunctions might work, is he aware that between January 2017 and 21, the Administrative Court has only issued one injunction?
Thank you. I thank my honourable friend for those statistics, which I wasn't aware of. But it does, relate back to some of the concerns I've had through the process, particularly on learning disability and how a family member who finds out during the process what processes would be open to them. In my opinion, it's unclear how the proposed panel fits into our legal system. Again, there are all kinds of quasi-judicial panels out there that do fit into our legal system and have appeal process, of course, but would normally see two parties in a case. And as I've said already, and I hear what's been said this morning about Spain, but in Spain, and it was put to us in our oral evidence, as I say again, from a supporter of the bill, that we should look at that part of the Spanish model about having both sides of the process, although I do accept that Spain has a very different legal system to the United Kingdom.
Thank you, Chair. I'm just interested in exploring this characterisation of two sides that is referred to, because this isn't about two sides. This is about an individual patient with a terminal illness. So I'm just interested in how we can explore that a little bit further. Chair.
And I hear that, and as you know, yesterday when there was an amendment on this, on individual autonomy, I voted to the same position as my honourable friend. But I put the scenarios to you that I put in that debate yesterday when I came to that decision. That there will be, the scenario that I've always considered is, what if that person with learned disability in their 40s or 50s says, I want to make a decision to relieve the burden from my parent in their 70s or 80s, and the parent in the 70s or 80s isn't involved in this process, but finds out about the process. And there is no, in my mind, way they can then intervene in the process. I hear what's said about JR, but there's no way, as is laid out in the bill, how they can then intervene in the process and say, actually, there's been a mental capacity assessment, but actually, we think that given there is a borderline level capacity, there may have been a position where a doctor has had to, under the Act, assist that decision to be made. What would be the legal process for the parents in that case? These are the scenarios. I'm not, as members know, I'm not somebody who opposes the principles of this legislation. But these are the scenarios that brought me to this place. Absolutely.
Yeah, thank you, Chair. I mean, the answer, the quick answer to that is it will be an injunction. But I hope you'd also be reassured that, remember, the panel is coming towards the end of this very long process. In the situation he describes, this patient would have gone through all the other stages with the doctor. I would imagine in that situation a psychiatric referral. The doctor would have said, would you consider speaking to your next of kin? So there's a lot of other stages prior to getting to this point, which I hope provides some reassurance.
And I hear that, and again, as my honourable friend knows, I've supported, as she has, Amendment 6. I've supported things that I think make matters stronger there. But I still do ask the question, you know, if you do find out later in the process, and I accept the right for autonomy, I said that yesterday, that unlike in Spain, and you know, despite the analogy that was made about this appeal in Spain, I don't think simply because in one case a religious group was funding the matter is an excuse for taking that away, because in other cases there will be people who in Spain may have very genuine concerns as to why they found out the matter and want to go through that appeal process. Absolutely.
I'm grateful to the Honourable Member for giving way, and just to sort of pick up on what the member for Spen Valley was just saying there, and to reflect on what I was saying yesterday about this, the multidisciplinary panel, as you say, is coming at the very end of the process. You've talked about, I beg your pardon, the Honourable lady has talked about the different stages, but they all occur in isolation. There's a doctor, and then there's a doctor, and then there might be a psychiatric referral. And we heard very clearly in the oral evidence about the value of that multidisciplinary panel referring to each other, taking evidence collectively. But the strength of it would be if it occurred at the beginning of the process. And I just wondered if the Honourable Member would reflect on that. Thank you, Chair.
Thank you, Chair. And I think that is the case. Clearly, as the Honourable Member said yesterday, you know, people from those professional fields, I think in their written evidence particularly, asked to be included in the process, but I don't think they were asking to be included necessarily at the end of the process. I think they were being asked to be included early in the process. Absolutely.
Thanks, Chair. The Honourable Gentleman has just given very clear, in personal terms, why it is important to involve the family, and the Honourable Lady, I can go with her points as well. But just taking back to this rather abstract question of whether there are two sides to these cases, I'm afraid, in contradiction with the Honourable Lady, I think there are two sides to the cases, as she herself recognises whenever she says this is a finely balanced judgment. The fact is, a decision can go either way, and it is very important that the decision makers are considering essentially two sides. It's not just this immediate stated wish of the applicant that is the only consideration, as the bill acknowledges. So would he agree that it is important to have as wide as possible an input into the decision so that genuinely both sides of the two options, to proceed or not, can be properly considered?
Thank you, Francis.
Thank you, Chair. From my perspective, the issue has, and I hear what the Honourable Member says, from my perspective, my concern has always been, if that case happens in the scenario I've described, you know, we as a committee, us as a House, if the legislation is passed, will have pushed this forward. And one death that somebody has concerns about the process, in the example I just gave, would be one too many. You heard me say that clearly on the clause 3 debate, and so that remains my principal concern. Not necessarily two sides, but in some cases where there are those concerns, we need to be clear that if this becomes law, that we've done everything we can to ensure that that does not happen. Sorry, I need to try to find where I was. So if I move on, I'd also query, just to query slightly, the resourcing of the panel. Clearly, part of the reason, in my opinion, why we've ended up here was because there were queries about the resourcing of the judicial part of the process. And clearly, still on the panel aspect, we would need to find those skilled professionals, especially consultant psychiatrists and social workers. We don't yet know. I know we can estimate how many cases of assisted dying we can expect to see each year in England and Wales. And of course we can look at the per capita rates in Australian states and American states to see that we could expect numbers in the low thousands. Any consultant psychiatrist and senior social worker who sits on these panels, of course, would have to spend hours, I presume, on each case, and we don't yet know how many hours that would be on average. And so for complicated cases, it could be many hours indeed. I would query, you know, what analysis we've undertaken on the capacity of consultant psychiatrists and social workers on that matter. I know their professional bodies are now beginning to look at that and collate that. But clearly, again, we weren't able to ask them that during the oral evidence, and because the way the written evidence was submitted so heavily in advance of these schedules and clauses being tabled, we haven't got that information in front of us. And we hear about resourcing in our NHS mental health services that we don't have enough psychiatrists at present. So I would query about the state of whether we have enough senior social workers. I have a senior social worker visits my house every year. I've never seen the same social worker twice, quite frankly, because of the turnover issues, the capacity issues, lack of staff issues there. I would ask what the government can do to make sure that the panels would be fulfilling their responsibilities. Clearly, you know, we would be dealing with people who've got very little time left, in the applicant, and clearly we need to be able to ensure we can properly staff those panels and making sure that's a priority and not taking psychiatrists and social workers away from, you know, other parts of what would currently be their work, and ensure that people that seek assisted death do not wait a long time. Again, that would have been a matter that we could have benefited from being able to ask witnesses during the oral evidence. We could also benefit, of course, if there'd been the normal consultation that you would have with a government bill, because we would have been looking at that matter for several months. In summary, Chair, the new set of clauses and amendments are accept an effort to fix concerns and problems with the original bill, but I think there are problems that still remain, and there are most probably some new problems as well, and I will not therefore be supporting a number of the new clauses and amendments. Thank you, Chair.
Jack Hunt.
Thank you very much, Chair, and it's a pleasure to serve under your chairship today. I'm looking to speak to a range of the new clauses really broadly, but also look to move a new clause 21E with the Commission, Chair. The first thing to say is I understand, and a number of comments were made yesterday around the fact that a number of members from across the House cited the judicial stage as an important reason why they supported the bill, although I would sort of challenge the notion that they voted for it exclusively for that reason, but I do recognise that there was a lot of strength of feeling. I'll be really frank, I wasn't one of those. I wasn't persuaded, actually, that that would be the case for me. Not least a number of points my honourable friend from Rother Valley made yesterday. I wasn't hugely convinced that this would be anything other than a rubber stamping exercise, and I'm certainly not going to go into the sort of good doctor, bad doctor phrase. I've got huge respect for the legal profession, especially given there's so many people here today representing them. In saying all of that, I think it would be justified to say that, yes, the legal profession has a huge range of expertise and experience, but they haven't, and they couldn't be expected to cover in the depth and the knowledge some of the other aspects that we've been raising concerns of for weeks now when it comes to things like psychiatry and social care. And so for that reason, especially given that we retain in this sort of triple threat approach, as it were, legal experience and directive on this panel, in association with social workers and psychiatrists, I fail to see how anyone could reasonably argue that this is a weaker approach. In my eyes, this is a much stronger one at all. And of course, there'll always be people who say, and we've heard it a number of times, this approach doesn't go far enough. I'd probably say that for some people, though, as we've already heard and has been acknowledged in the room, that no amendments that will be passed in this process will ever convince everybody that this will ever be safe or good enough. I think there is also a really uncomfortable truth that is rarely recognised, I think, but I think it's worth saying, although I'm sure I'll be misrepresented on social media for saying it shortly. There is no safeguard that we could possibly put in to any bill on any question that will 100% make sure that there will never ever be any mistakes that happen. And I fully appreciate that we have to do our level best into ensuring the probability is reduced to an absolute minimum. But when you go into surgery, there are always going to be complications that you can't see. Yes, we know absolutely there have been awful miscarriages of justice. We've spoken about them as a new government, from the post office scandal to infected blood, etc. But we also have to rely on the fact that we are entrusting experienced, trained professionals to carry out this work, and that not only more often than not, in nearly every circumstance, bar those awful cases that I'm sure we're all aware of, that they do their work to the best of ability. So I think we have to be absolutely honest about that. And I think it's really fair to say as well, we shouldn't look at these new clauses in isolation. They are part of a package, and we've seen a number of amendments passed when it comes to coercion, for example, to make sure that medical professionals are trained to the right standard. I hope, like my honourable friend, we will be seeing further amendments when it comes to special educational needs and learning disabilities. I think those things are really, really important. So I think it's worth also recognising that, as well as the new clauses, and in my view, a much stronger approach to this final final judgment, as it were, we have also passed a number of amendments too. I also want to pick up this issue around whether it should be adversarial or inquisitive. I'm sure my friends in the room who have served at the bar or otherwise will tell me if I'm wrong, but in my view, an adversarial process is one of competition. It pits someone who's trying to prosecute an argument against, for example, an inquisitive approach would be asserting the truth. And in my view, we shouldn't be approaching this, people who are going through not only agonising pain, but agonising decisions about what to do with the remaining days of their life. I do not think that those people should be on trial. I think we should be approaching this not as from a position of suspicion, but a position of support. And of course, that is caveated with all the things we've talked about when it comes particularly things like coercion. And any kind of idea that a person has been coerced into their decision, of course we should investigate. But this shouldn't be an adversarial process. And the kind of connecting element to this as well is making sure we don't get the balance wrong between safeguards and safety. And moving us into a position where we're adding on so many barriers and layers that, number one, actually you can't ever access the process because it becomes too cumbersome, etc. But I don't want those people in the remaining days of their life having to sit in endless meetings and consultations and an adversarial court process or whatever it might be. Yes, absolutely, we have to ensure all the right safeguards are there. We've said a number of times if there's any suspicion or otherwise that someone may have been coerced in the decision or that they don't have the mental capacity, then of course we will go down the relevant routes to make sure that hasn't happened. But, as I said, part of the reason people will likely make this decision, as we know, is to have the autonomy to go out in their own terms, but they can plan the remaining months and enjoy that experience or with their families and make sure those precious days are spent with their family and not in endless meetings rooms as well. So I think we absolutely have to get that balance right. I know it's been acknowledged already, but the point around diagnosis is a really important part of that. We regularly talk about the 6-month point in terms of diagnosis, but we know that many people, when they receive their diagnosis, actually their final days will be much shorter than that as well. So people don't have time either in the main to go through a really lengthy, difficult process.
Will you wait?
I will, absolutely.
I'm grateful to, I mean, he's making a case against a third stage altogether, I think. Is he not? Well, I'd be grateful for explaining. If his concern is about asking patients to go through a third stage after the doctor's assessments, then, well, in that case, what is the difference? I mean, it's not necessarily the case that the judicial stage has to be incredibly either time-consuming or onerous or distressing for the patient. It's about the legitimacy of the process and the rigour that it's applied to it. But if his concern is just to speed people through it without going through the distress of further explanations, then surely he should be objecting to the panel as well.
I thank the honourable member for the question, and I would probably say you're entirely misrepresenting my position on this. I'm not for a minute, and I've used the word balance between safeguarding and making sure that this process works for people. And I've said, I've just spoken in support of this panel stage. I think it's important, it's robust. We're including social care workers and psychiatrists alongside legal professionals. I'm not for, and I haven't for a moment used any language at all which would suggest I'm not in favour. What I'm saying is, and it's referring to, it doesn't go far enough, that we've spoken a number of times about adding additional layers beyond these sorts of set processes which are already in the bill and being debated today. I will. will.
I'm grateful. I'm very happy to clarify. I wasn't suggesting he did oppose the panel. I recognise he's speaking in support of it. My concern was that he was suggesting that there was a problem with the High Court stage. I appreciate what he's now objecting to is some sort of fourth stage that some people might be suggesting on top of the panel. I'm personally not proposing that. I think they should have this multidisciplinary team as part of the assessment process and then a judicial stage as originally planned.
If I wasn't clear enough, my misgivings about the judicial stages, and I'll set them out again, is, in my view, the people making a High Court judgment probably didn't have the breadth of knowledge and experience to pick up a number of the things we've been debating over the past few weeks. You can't expect legal professionals to also be experts in palliative care or psychiatry or whatever it might be. So that I was actually saying that I had misgivings about that for that reason, and I think the approach this panel is taking is much more broadly in line with some of our misgivings here. So I think this is an enormous improvement. So neither was I saying we should remove this stage, neither was I saying we should dilute it or anything further. In fact, I'm saying this is much more robust and puts in the right safeguards that we've been talking about, whilst getting the balance between safety and recognising that people don't want to spend the last days in their lives in perpetual meeting rooms, etc. We've also spoken a number of times around coercion, and I think it's an incredibly powerful and important argument. And I think, you know, again, I'm sure my comments will be misrepresented, but we have to be clear that actually some people in abusive relationships, which are pernicious, which are evil, which are very subtle, as the honourable member has mentioned on a number of occasions, and I would absolutely agree. There may be some abusive relationships which will encourage their partner or whoever it might be not to go through assisted dying, so they extend their days in pain and agony as well. We have to recognise that abuse takes many, many forms, and it's endemic in our wider society. And I think this goes back to my point around why it's important that we have a wide range of expertise on the panel. Because if we do have psychiatry, if we do have experts in the field beyond legal professionals who've had experience in this, I think that's really crucial. And as I said, it's important not to look at this new clause in isolation, but it's to do it in parallel to some of the other amendments we've passed, such as Amendment 21, which is specifically talking about coercion and training, etc. as well. So I think that's incredibly important to look at it in the main. The last couple of things I'd just mention really broadly here is this question of capacity and burden as well. And I think we've spoken a number of times about not being able to police discussions. I wouldn't necessarily go that far. I recognise absolutely that the relationship between the assessing doctors and the patient in the immediate term should be one that approaches this in the right way. But I would also say these conversations take many, many forms and can be articulated in many ways, ones beyond which we can legislate for. We've said, for example, about the question of burden, and we use the example where if I said, for example, as someone who's just got a terminal diagnosis, yes, I don't want to end the remaining days in absolute agony and fear. I also don't want my family to go through that. I think that shouldn't preclude me from going through that decision-making process, but I appreciate the nuance and the difference between someone saying or hinting at that the decision's been taken out of their hands. The other reason is one of depression, for example. Sorry to put this incredibly glibly, but if I got a terminal diagnosis, I would feel pretty depressed about that. I may also be clinically diagnosed as depressed. But some of the amendments that have come before, and I think it speaks to this as well, is should my past medical history, let's say I've suffered from depression a number of times in my life, should that preclude me from also going down this process? Or one of my family and friends, and I think it's a really powerful argument about family and friends, said, well, actually, Jack has suffered from depression at 2 or 3 moments in his life. Maybe he shouldn't actually access this. But I would like to think that I'm making the right decision. So again, we've got to rely to a degree all the time on a doctor, a psychiatrist, or anyone else to use their good professional judgment over whether this person's depression or otherwise is impairing their fundamental judgment to go down this route. And I don't think we can ever legislate 100% for that. We have to trust and rely on the good practice whilst giving them the training, skills and safeguards that we need to go down this route as well. Specifically on the role of the Commissioner, and I realise that there is a particular amount of interest in this. I think this is a fairly regular procedure that we would have individuals who are ultimately held to account in their various guises across the board. I'd suggest actually if there wasn't that single point of reference, people would be equally upset, shall we say, that there wasn't that person who could ultimately be held accountable for the wider system. It'd be the same if we had the High Court system or retained it. People would say, quite rightly, I would argue, well, who is actually overseeing this process? And so I think the Commissioner, with the kind of safeguards, the ultimate people responsible would be the Prime Minister and indeed the Secretary of State for Health or the relevant appropriate authorities. My one question on this, if I may, and perhaps the sponsor of the bill may be able to answer it later on, and it might be that the Honourable Member, is what would be the role of the Commissioner in Wales, for example? Who would be appointed? Would there be a separate Commissioner for England and Wales, or would the Secretary of State just appoint one Commissioner for both jurisdictions? So I think that would be worth considering. And so I'll leave it there for now in terms of the broad arguments, but just speaking to new clause 21E, which was tabled by my honourable friend, member for Hilton and Bradley Stoke. They continue on from the themes that I was proposing in my amendments 414 and 415. I'm grateful to the sponsor bill and indeed the rest of the committee for supporting these in terms of making sure that there's an informed consent procedure in the bill. Now, this amendment seeks to ensure that equity in the ability of everyone who otherwise meets the eligibility criteria and who wishes to request assistance as set out in the bill. As currently drafted, the bill makes provision that the eligibility panel may hear and from in question the person or person who made the application for the declaration. They're able to question in person the person who made the application declaration. And it clarifies, and I quote, that the person includes by means of video link or a live audio link. And I think this is sensible because, of course, we all know that travelling to a specific venue simply would not be possible for a number of people due to their specific medical conditions. However, the challenge around equity arises as several terminal illnesses, unfortunately, also see people face significant, prolonged and unplanned pain episodes too. And this would make appearing before a panel via a live link at specific booked time slots all but impossible to some. And this would unduly and unfairly delay their wish or make their wish more difficult to request consideration for assistance while they're in pain. So further panel appointments may not be straightforward to arrange because we've got a number of people there, and the same may happen again. And pain is not plannable, as we all know. I'm sure none of us in this room would think that this unintended consequence would be in keeping with the intention of the bill. And this simple but important amendment, in my view, would make for the provision, where needed, otherwise eligible adults to pre-record their answers to the very same questions set by the panel in advance. I will.
I think this was actually a very sensible amendment, not least because there are some conditions where people experience very significant decline at the end and may, in a matter of days, for example, lose the ability to speak while retaining capacity and all the rest of it. So having it pre-recorded in a small number of cases available for them, I think would be incredibly sensible.
I thank the Honourable Member for his question, and I agree wholeheartedly. And I think it's important to emphasise these will be a relatively small number of cases, but I think it's a very important provision which the bill should provide. This would be subject to clear guidance developed following the passage of the bill, as with the schedules and other related items, and through those subject to the same safeguards as would be the case for a live link provision, which are already included in the bill. And essentially, this amendment provides equity of access to request assistance for all otherwise eligible adults, no matter the pain and any other specifics of the terminal condition they face. Nobody should have to wait longer because of the pain they are in. My honourable friend is tabling this amendment based on experience. A close family member of hers, who has a terminal illness, has been experiencing pain episodes that would make it impossible to plan to join a meeting with the panel at a specific time slot via a live link. This would only increase stress and distress at an already incredibly difficult time for both her and her family. If this bill was legislation, it would not feel right to exclude anyone eligible from being able to request assistance if that was their wish due to the impact of the terminal illness itself. I encourage fellow members of the committee to join me in supporting this amendment. And just as a final point, because I do appreciate this has come up a number of times, and I'll admit quite candidly, it was a small factor in my thinking when I came to vote the second reading. And this is around bandwidth, and by that I mean the bandwidth of the professionals we're asking to do this work. Now, I think we've done very well to keep politics out of this room by and large, given, which is extraordinary given the amount of time we've had in there. But there was a couple of moments of candour, I think, from members opposite, where they expressed concerns whether the NHS had the capacity.
At 11:25, the sitting is suspended until 2 p.m.